United States. Pursuant to adjournment, God save the Constitution and Honor Court.
Good morning. Please be seated. Okay, the case before us is the City of Houston versus Houston Firefighters Relief and Retirement Fund. Can the parties make their announcements?
Megan Brown on behalf of the City of Houston and the other city parties.
Melissa Mather from the Texas Attorney General's Office on behalf of the state as intervener.
Okay.
George Shipley from the Houston Firefighters Fund. And this is my colleague, Amy Maddox.
Okay, let us begin. Oh, Mr. Brown, I have a question for you. I'd like for you to begin by commenting on two cases. One is the Vincent v. Burgess and the other's Holbrook versus G something. The city, the fund is saying that it's unconstitutional as applied because the legislation as applied infringes on the purported exclusive authority of the fund's board to determine the sound actuarial assumptions. How does that claim fit with those two cases?
I don't believe that the claim fits whatsoever, Chief Justice Raddick, because Vincent by the Texas Supreme Court held that the term shall, as used in any type of provision, including a constitutional provision, does not mean sole and exclusive authority. Shall has been interpreted by other cases. It could be discretionary or it could be mandatory, but it does not establish sole and exclusive authority. That is what you would have to see in the plain language of Section 67F of Article 16 of the Texas Constitution. And as much as the fund would like it to be there, it is not there. And of course, the plain language is not only the starting point, but can be the ending point in any constitutional interpretation.
Well, they say that the legislative history is what is almost outcome determinative of determining these meaning of these two statutes. So perhaps you'd like to comment on that.
The legislative history begins
and try to
really
be specific if you can.
Yes, the legislative history really begins with the adoption of Section 67 to the Texas of Article 16 to the Texas Constitution. And probably the best exposition of that was the Attorney General's opinion, Jim Maddox's opinion in 1990, which I believe is JM 1068, where it discusses how the legislature in Article 67A1 was given the express power to create pension systems within the state of Texas. And that opinion also explained that the state of Texas was imposed with a duty, in fact he called it a fiduciary duty, to ensure that the financing of benefits was based on sound actuarial principles. What happened in...
You mentioned that Attorney General's opinion was 1990.
That's correct, Justice Hunt.
Wasn't 67F though passed in 1993?
It was, and there was separate legislative history regarding Section 67F. Specifically, there were two different House Research Organization analyses, which of course, remember, this can't trump the plain language of the constitutional provision.
Does legislative history become involved separate and apart from the plain meaning of the language? Do we need to look at the legislative history to determine the plain meaning of the statute?
You do not need to look at the legislative history to determine the plain language, because the plain language of Section 67F does not state what the fund would like it to say, which is sole and exclusive authority, and more specifically, it does not say that the pension fund board is empowered to enact or create or formulate or adopt, as the term is used, every single actuarial assumption that is used in the pension system, to the exclusion of any actuarial assumptions or legislative scheme. Because what that does, Justice Hightower, it really turns the relationship of the legislature and the administrative agencies it creates on its head. Because, and again, the fund, in fact, this court basically referred to the fund in 2003 in an opinion called Williams versus City of Houston. This court referred to the fund as a public administrative body, and its board basically is an administrative agency. Administrative agencies derive their power solely from statute and the express language of the statute, not from the Constitution. And so what you have here is basically where the fund is arguing that an administrative agency that's created by the legislature, that can be dissolved by the legislature, and certainly the act creating it can be amended and was amended numerous times between 1975 and 2017, that the administrative agency somehow can trump all of that despite the absence of express language either empowering the pension funds board to do anything, or specifically empowering them to adopt all actuarial assumptions to the exclusion of what the legislature wants.
Well, obviously, in looking at the plain language, we have to look pretty closely here at the words shall and adopt. And you've talked about the word shall. But as far as adopt is concerned, the fund suggests the proper definition for adopt is to make one's own by selection or assent, to choose or take one's a self, or take into choice into a relationship, I presume, is to adopt a child. If we accept the fund's definition, does that necessarily in itself establish the board's right to have the exclusive authority?
Absolutely not, Justice Hightower, because again, the absence of any language in Section 67F or any other part of Section 67 that empowers the funds board to adopt, choose, let's say, every single actuarial assumption to the exclusion of any assumptions that the legislature creates or any mechanism. But let me return to the question you asked me about the 1993 legislative history. Even though it is not necessary to reach this because the plain language resolves it, the 1993 legislative history shows that what happened in 1991 was that the legislature amended the government code to create Section 810.001. What that did was it basically permitted virtually every single political entity and subdivision in the state of Texas to create its own pension system with no rules, no standards, nothing. They don't have to have a board. They don't have to hold the assets for the exclusive purpose of the participants and beneficiaries. They don't have to select an actuary. They don't have to apply sound actuarial principles. And the legislature obviously was concerned about this gap that it had created in 1991 when over 300 systems had been created. And so what they did in 1993 was to close that gap by imposing a duty on the part of the funds board or the pension boards to select an actuary and adopt sound actuarial assumptions to be used in the system, not to be used to the exclusion of what the legislature had the power to do and what it did, in fact, in 2003. Because in 2003, the legislature specifically changed one of the actuarial assumptions in Article 6243E.21, which concerned the amortization period, and changed it from 40 years to a constant period of 30 years. That is one of the very actuarial assumptions that is in 2190 that is now in the amended version of 6243E.21. And so the notion that the legislature doesn't have the power to do that is belied by what it did in 2003.
And not to get too far away from the legislative history, but the fund is saying that the 67F was created to protect them from cities and municipalities and whoever has the authority to create that fund to keep them from raiding. So that's the other way.
Again, that's one of the points in that particular legislative history, Chief Justice Raddick, but that doesn't affect our situation one iota. The reason is, again, these pension systems that were created by governing bodies after 1991, again, they had in many cases no rules whatsoever, no board, no anything. The governing body is who created that system. The City of Houston did not create the pension fund. The legislature did. And so the city of Houston is without power to so-called raid the pension fund. And I know that the fund has argued that, well, because you are able to prepare a risk-sharing valuation study that is counter to or different from the fund's risk-sharing valuation study, that somehow, in their words, negates the ability of the fund.
It could greatly reduce the amount of the fund, of the city's contribution.
It could reduce the contribution, that's correct, Justice Hightower, and in fact it has in certain years, although we're not seeing that now today. In fact, this statute is working exactly like the framers of it intended, because what's happened is that the unfunded actuarial accrued liabilities have gone from over $900 million at the time this statute was enacted to now they're around $330 million. And the funded ratio has gone from approximately 80% to where now it's over 93%. So this notion of raiding the pension system, the city doesn't have the ability to do that. The legislature made a choice here, and the choice they made was that all of the participants meaning broadly, the city, the board, the participants and beneficiaries, they all have risk here. The risk obviously is to everyone if the city goes under and can't fund the pension payments.
Mr. Brown, I want to talk to you a second about the city going under. How can we consider that when we're kind of engaging in a textual analysis? Does the effect on the city of the interpretation come into play? And if so, how does it do that?
Part of what, Justice Landau, what we've been talking about in respect to the legislative history, we've been talking about a broader test that includes not just the legislative history, but the situation, the times that we're in at what time these different acts and constitutional provisions were enacted. At the time, in 2017, and it's not some newspaper article, it is stated in the bill analysis of SB 2190 that the city could not finance in the future these enormous pension liabilities absent a change to the statute. Now, is that determinative of the plain language? Of course not. The plain language of 67F says what it says, and it does not say what the fund would like it to say. But I think what it does, Justice Landau, is it gives you a sense of what we're involved with here, because one of the tests that courts use in determining the constitutionality of a statute is to make sure that you give it a reasonable construction so that absurd results are not produced. If the trial court's judgment is upheld, what we're going to have is a situation where 6 separate pension statutes effectively will be unconstitutional besides this one. Why? Because in those 6, either no actuarial assumptions of the board are being used to determine the municipality's contribution rate, or there are certain assumptions that have been adopted by the legislature that are used in conjunction with other assumptions used by the board. Well, if the fund's position is correct, that only the board is empowered over the legislature, over everyone, to select every single actuarial assumption, all those statutes are unconstitutional, and that's an absurd result. I think the rest of the time, I believe, will be used by the state.
Can I ask one quick question? I had a question, just a procedural process question about the plea of the jurisdiction.
Yes.
So, when we're reviewing the city's plea of jurisdiction, you argue in your briefing that the city's governmental immunity is waived only if there is a viable constitutional claim pled. So therefore, to determine whether the trial court properly denied the city's plea of jurisdiction, aren't we essentially deciding whether Senate Bill 2190 is constitutional as a part of the plea of the jurisdiction?
I think as part of the plea of the jurisdiction,
we have to meet that on the merits at that stage.
That is correct, and of course the 14th Court upheld Judge Kerrigan's determination that the plea of the jurisdiction should be granted because there had been no valid or viable constitutional claim pleaded.
Thank you.
Thank you, Your Honors.
On behalf of the state, we support the city's position in this appeal, both with respect to the constitutionality of the statute and with respect to the arguments regarding res judicata. And just to go directly to your Honor's questions, certainly our position...
Is your role here as an intervener?
Correct, Your Honor.
Okay.
Exactly. We intervened on behalf of the state to defend the constitutionality of the statute, and that's our statutory role in certain cases.
Okay.
And just to take the court back to the plain language of the statute, that is exactly the problem that we have here, is that what the fund has cobbled together is a sort of strained interpretation of various words in 67F, and they're encouraging the court to travel out on this very thin reed to find some kind of constitutional problem with the statute that the legislature passed. And what I would encourage the court to do, look at the text of the statute of 67A and 67F together, make it clear that the legislature has the authority to regulate the fund and make sure that there are sound actuarial principles being used. That's exactly what the legislature did. This very narrow, twisted interpretation of one word, adopt, in 67F is not enough to overcome the essential canons of constitutional interpretation, which would lead the court to find the statute constitutional in all possible instances. So the fund is really urging this court out on a very thin reed to try to travel with them on this road to get to unconstitutionality.
From a timing standpoint, the fund makes the argument, as far as harmonizing the two statutes, looking at them, constitutional provisions, looking at them as a whole, is you have 67A that's passed, and then you go 17 or however many years later, and then you have F. And they've argued that the timing of it could appear to be a more specific limitation to 67A to the F to the powers that are in A, by intending that the board, not anyone else, would have those powers. And otherwise, why is 67F there?
My first response to that, Your Honor, would be this: whenever we find ourselves characterizing their positions as could appear to be, or might be, or if we squint, can we see it, we're automatically out of that first canon of constitutional interpretation, which is to use all possible ways to find the statute constitutional. So that's the first thing I would say. Secondly, again, this kind of reaching back to the history to try to make these words mean something than what is on the page. This is exactly why we are all textualists now. We are using that plain language to get to the right result. I see my time is up, and I have a short rebuttal. Thank you.
Okay, Mr. Shipley, my original initial question was really addressed to you. So I was thinking that he might comment on it, but so you're making the claim that as applied, you have the exclusive authority. But what about Vinson v. Burgess?
Yeah, in
Would
Vinson.
you distinguish that for me?
Yeah, in Vinson, that was the commissioner's court, and there was a statute that said the commissioner shall levy the tax rate, but in the same section of the code, it also said that other entities could also levy a tax rate. And therefore, in that case, they said, well, even though it said exclusive, it's not really exclusive because you have to construe the statute as a whole. So it wasn't exclusive. In Halbrook, it was a question about the DA's authority, and it said that the DA, quote, shall exclusively represent, end quote, the state in criminal matters, and then shall, quote, shall represent, end quote, in any court. And so there was, again, there were two different, even though they used the word exclusive, it clearly could not have been exclusive because in the same statute, and it gets back to the principle that I'm going to talk about, is that when you construe a statute or a constitutional provision, you have to give meaning to all of the constitutional provisions. What they have failed to do since we filed this suit years ago was they have failed to give meaning to 67F. Before I move to that, I would like to make it clear, we're not here, this is a question where we're looking at the constitutionality of the statute, 2190. But there is no dispute, there's no ambivalence, there's no uncertainty about what 2190 means. We're not construing the statute that's ambiguous and saying, oh, well, this way if you construe the statute, it might be constitutional. There's no doubt, we know what's happened. 2190 has been applied. It has forced the board to use actuarial assumptions that it did not want to use. There is the mandatory assumptions that were implied, that were required by the statute.
Mr. Shipley, can I ask you a question about that?
Yes.
Did the board adopt, beyond the 4 required actuarial assumptions, any additional assumptions?
Yes, they did.
And what were they?
Well, there's at least 8 other assumptions, and they were adopted and they would have been used. They were actually used in the valuation, the initial valuation study that the fire fund did, and then the city also did their initial valuation study. The board used other actuarial assumptions that it wanted to use, and then of course, as you know, when they compared the 2 valuation studies, they were more than 2% apart on what the contribution rate would be. They were about 10% apart. They couldn't get it worked out. And so they ended up averaging to come up with the contribution rate. So what that means is the boards, even in addition to the 4 that are mandated by the statute, there were other actuarial assumptions that the fund wanted to use, and they're not used. They got the 2 things were averaged. So what that means is that if they had used the actuarial assumptions that the board adopted and wanted to use, the contribution rate would be significantly higher. Instead, they didn't get used, they got averaged with the others.
Let me ask a question, because we've talked a lot with the city about the plain language of the provision.
I'm a textualist too.
We all are now.
We are.
I
agree with Judge Sotomayor.
Just looking at 67F3, provides that the board shall adopt sound actuarial assumptions to be used by the program. I mean, as far as it shall select legal counsel and an actuary, F3, and adopt sound actuarial assumptions to be used by the system or program. But nowhere in there does it say exclusive or sole right or limited to or or to adopt the sound actuarial assumptions. Aren't you asking us to somewhat write the word exclusivity into F3?
No, and I'll tell you why. If we could start, I'd like to look at 67 as a whole, which we agree that you should do. If you look at section 67A, which was passed in 1975, constitutional provision, it's a general provision. That's how it describes itself, a general provision. It says the legislature may, not mandatory, enact, and then it simply says that financing of benefits must be based on sound actuarial principles. It doesn't say who is going to make sure they're based that way. It doesn't delegate any obligation or authority to anybody. It simply says as a general statement, financing of benefits must be based on sound actuarial principles. That includes actuarial assumptions, but there's actuarial principles, there's more to it. So that's what the law is. Now, you go to F, and if you look in the Byers versus Peterson case, which we've cited for you, they tried to write it off as saying, oh, that case only applies if you're comparing a constitutional amendment to the original Constitution. That's not what the case says at all. That case says, how do you reconcile possibly incompatible or different provisions that may contradict each other? I want to be clear. We don't think A and F are contradictory at all. We think they can be read together. But according to Byers,
you don't think under A that the legislature can require certain assumptions to be used? By financing of benefits must be based on sound actuarial principles.
They might have been able to do that, but when F got passed, and F is specific and it's subsequent in time, and it only applies to retirement systems not belonging to a statewide system, in those cases, which is clearly ours, it says that the Board of Trustees shall select legal counsel and adopt sound actuarial assumptions to be used by the system. If you delegate that obligation and authority to the board by the Constitution, it's not delegated to anybody else. It's been exclusively delegated to us. I think this is a textual matter. I think it's clear. That's the way you read the statute. Otherwise, what does 67F mean? Because what they want to say is they've kind of given you three options. Well, 67F just repeats what 67A means. Well, if that was true, why do they have to say it at all? Or they say, and then if that's what it would say, they could just say, well, the board shall use sound actuarial assumptions. It wouldn't have had the language that the board shall pick the actuary and adopt the actuarial assumptions to be used in that program.
Well, but you did adopt actuarial assumptions in addition to the ones that are mandated.
Yes, we did. But where's the authority for the legislature to impose actuarial assumptions in light of 67F when the only entity to whom the Constitution gives that power is to the board? I think that's the clear text, and that becomes even more clear if you look at the legislative history, which is from the court's record at 39. So the House Research Organization, it's very clear. It says Proposition 11, which is 67F3, would stipulate that the Board of Trustees, not government entities, should have the fiduciary responsibility for system assets. It would give the trustees exclusive right to administer the system and assure that the local government entity cannot raid.
But isn't there a difference between administer and adopt sound actuarial principles?
No, I think that's what...
Because that's a different provision that's in 1, and the adopt sound actuarial assumptions is in 3.
I think this adopting sound actuarial assumptions is a more specific delegation of authority. It's more specific, it's more recent, and it's more narrow than principles in general. This whole case hinges on actuarial assumptions. We're not saying that they can do a lot of other things, but they cannot impose actuarial assumptions on the board that the board has not chosen to adopt and use in the system. The other part of this is at page 40 of the court's record. It says that the duties of the pension trustees need to be specified in the Constitution, so they cannot be changed by the legislature in response to political pressure. Placing the authority in the Constitution would give more standing than just having it in the statutes, which can't be changed. So that's what the legislative history is. So both textually and through legislative history, it makes sense that, yes, A has its general, if you're going to do this, you have to use sound financing principles, but F is more recent, it's more specific, and it says that the board shall adopt sound actuarial assumptions to be used. What they want to say is that means, you get to adopt some of them. Their argument, taken to the extreme, as long as you get to adopt one assumption, you're constitutionally consistent with 67F. Or they say, we can just force them on you, and if we make you use them, but then that ignores the language of adopt.
I think they're saying that because 67A doesn't have the language sound actuarial assumptions, that was delegated exclusively to the fund. Is that what you're saying?
That's what I'm saying, that 67F says that because it does have sound actuarial assumptions in 67F, the obligation, responsibility, and power to adopt sound actuarial assumptions belongs to the board only. And that makes perfect sense because the board has the fiduciary duty.
The case that the the state that you cite, which was California, I can't find it anymore, but basically that language you quote it and say, look at California, because they also found that it was exclusive. Right, but the language is different, and that's different than what the Texas statute says.
Well, our briefing wasn't clear because all we were trying to do with the briefing that other states were doing the same thing was not the specific language, but that it was the mood at the time that a lot of pension funds, a lot of states were concerned that government agencies were raiding or shortchanging pension plans. And so one of the things that you're entitled to look at in interpreting the constitutional amendment is, you know, what was going on at the time. That's all that's for.
Okay.
Clearly, if you find that we have to have the word exclusive there, that, you know, we don't, but I don't think that's what the text says. That's not what the legislative history, from the text and the legislative history, and the fact that the Constitution does not delegate the obligation or power to select the actuarial assumptions to anybody other than the board, that's why we should prevail. They have never given meaning to this language. As I've told you earlier, they said, oh, well, as long as you get to do one, or if we make you do it, you're adopting an actuarial assumption. That's a torturing of the language that makes no sense.
What about the city's arguments about the fund's interpretation of 67F would have the effect of making unconstitutional at least 4 or 6 or other pension statutes?
You know, I've heard that. I frankly, they have not explained it well enough for me to even understand it. And with some of the cases that they're talking about, they seem to suggest or imply that other funds who like have a flat contribution rate of 8%, that somehow your ruling here would hold those unconstitutional, and that's simply not correct at all, because if you're not using actuarial assumptions to make those decisions, it wouldn't be unconstitutional. But more importantly, look at what has happened here. This is more of the sky is falling for them. Judge Miller only held 2190 unconstitutional as to the fund. Nobody else, the fireman's fund. Remember, the statute also governs the the police, and the city employees. They apparently actually agreed on all this. They apparently worked it out. There has been no constitutional challenge. And Judge Miller, even in the same statute, said nobody has suggested that these other funds are now operating under an unconstitutional statute. His ruling only applies to the firefighters fund, only. And so this is just more of this stuff about, you know, their claim in their statement of the case that there's going to be a catastrophic economic crisis or something like that. First of all, the suggestion that a court, in interpreting whether a statute is constitutional or not, should consider economic or political outcomes, there's no support for that. But secondly, there's nothing in the record to support it. And the fact is, the only thing that they have cited, and they cite it in their brief at page 12, is from the court's record at 158. It's a Houston Chronicle unsigned political ad. That's what they cite to say that there's going to be some catastrophic economic calamity. Don't you know? So it's not relevant. They don't have evidence. And don't you know that if they could have really put on evidence, how hard it would be for the mayor or the comptroller to come over and get on the stand and testify this is going to have some significant impact.
Well,
but that has no place in the decision.
The issue is whether the fund is sound, not whether the city's going to be sound.
Yes, and the fund is sound. The fund was sound before this legislation. There's no dispute about that. The firefighters fund was sound before the legislation in 2190.
Let me ask a question, changing gears here. If we were to determine that 2190 is unconstitutional for the reasons stated by the trial court, which mainly reference the actuarial assumptions, can't other portions of 2190 be left intact that may not apply to the actuarial assumptions, such as provisions changing benefits or increasing the members' contributions rate? I know your brief
Yeah.
says it can't be,
Well-
but it seems there are some things that don't necessarily relate to the assumption rate.
Yeah. Well, first of all, keep in mind that he only invalidated the statute as to the firefighters fund.
Right.
So I don't know whether you call that a severance or not, but he didn't overreach.
But within Article 1.
Yeah. Secondly, with the end of our brief, I think starting around page 50 or 52, we go through the litany of, there's scores of provisions in what was called a comprehensive statute that are touched on by the actuarial assumptions. And it's not going to be easy. First of all, if that's what they wanted, they should have asked for that and argued for that and explained to Judge Miller how to do that. They've argued that for that here, but they don't say anything other than say you should do it. They haven't tried to explain how they can do it or that it can be done.
Would that be something to be sent back to the trial court, or?
Yes, I think that if this panel were to conclude that, yes, Judge Miller's order should be upheld, it's unconstitutional, but you have concerns about whether portions of it can be severed, and you can't do it, yes, I think it would be appropriate to send it back to the trial bench for that.
Are there fact questions involved in that process?
I don't know, because I don't know how they're suggesting it can be done. We've looked at it, we tried to do a red line, and it's just a nightmare because the actuarial assumptions sections are referred to so many places in the statute. That's the problem, is how do you start redlining? It's very, very difficult to do.
So your argument's it's too entwined.
We think it's too entwined, but we also understand the court's concern. I mean, you haven't got any help from the defendants to explain how you would do this. And if you're uncomfortable with it, we think that would be appropriate to send it back to Judge Miller for him to take a closer look at it.
Have there been other examples like this in an as-applied challenge and the question of severability in a very complex statutory scheme have come up? Are there other cases we might look to for that?
Offhand, I don't know of any, but I mean, we did try to look at this, because look, we're not trying to blow the world up. We want the Constitution to be applied the way it should be, and I think Judge Miller did a reasonable job. And we looked on how to try to sever out, and we haven't been able to figure out a way to do it. I'm not saying it can't be done, and Judge Miller might be able to figure out a way to do it, but we haven't been able to figure it out. And they sure haven't explained to you how to do it. Thank you.
Thank you.
May it please the court, let me start with a question that you asked to both of us, Chief Justice Braddock, which I did not talk specifically about Holbrook versus Quines, which is directly on point, which this court held and the Texas Supreme Court affirmed, that when the use of the word shall is present, but there is no exclusivity language in that same provision, you cannot infer it. It has to be there, just like it was in the California statute that the fund cited. We don't have that in Section 67F. In response to a point that you asked about Justice Hightower regarding this argument that, well, because Section 67F was approved by the voters in 1993, does it have some controlling effect over the 1975 amendment to the Constitution? Absolutely not. That is a test, and Byers versus Patterson expressly said it only applies when we're talking about a comparison to the 1876 Constitution, not to an amendment to that Constitution and another amendment. Instead, you follow the rule in In re Nestle, the Texas Supreme Court, Oakley, Texas Court of Criminal Appeals, in which all amendments that we're dealing with are to be read and construed together as if they had been adopted at the same time. But even then, what the line of cases talks about back in the 1876 context is this is a last resort test. When a court has determined that there is simply no way to reconcile irreconcilable constitutional provisions, we don't have that here. And so certainly this last resort test doesn't come into play. Justice Landa, you asked about the other assumptions that the fund has adopted in connection with. And yes, they have adopted other assumptions. That's a policy choice that the legislature made with respect to the adoption of assumptions. It preserved the right, certainly, for the fund to make assumptions. The policy choice was how those were to be reconciled with respect to the city's contribution rate. And it gets back to what you asked about, Justice Hightower. Well, can you reduce the contribution rate? Yeah, you can do that. But remember, both actuaries have to follow sound actuarial practices. There has been no claim in this case that a single actuarial assumption involved either by the legislature or anything that the city has come up with is unsound.
Would that include the assumptions made under the pre-amended statute? Were those all sound?
I don't recall what the fund's position is. I presume they take the position that they were sound, which again gets back to the 2003 amendment where the legislature changed that actuarial assumption regarding the amortization period. The question was asked about, and I don't remember whether it was you, Justice Landau, or you, Justice Hightower, about this administered process. Yes, that's a separate duty that has been imposed on the board, and that duty is one that the board has to administer the fund, and that is not a power, but it's a duty. And then, with respect to finally, Chief Justice Raddick, on going back to Vincent, I mean, what Mr. Shipley said, I think, demonstrates our point perfectly. Because under Section 67, and again, this is in General Maddox's 1990 opinion, which is that it is a shared duty on the part of the legislature and the pension boards it creates to ensure the actuarial soundness of the system and that sound actuarial assumptions and principles are being adopted. That's exactly what Vincent involved. It had shall with respect to the Commissioner's Court and other entities. And the Supreme Court said shall by itself, without other language of exclusivity, does not imply or connote sole and exclusive power.
Thank you, Your Honors. I'll just say a brief word about res judicata, which we haven't really covered very much, and I just want to make sure that we raise those points again for the Court's consideration. This issue about what the meaning of the word adopt is has been litigated over and over. There have been so many briefs filed on the issue, citing Vincent and citing the Holbrook case. We've just gone round and round about that. That is a perfect example of why we have res judicata in our system. We do not permit serial litigation to just keep going on and on about the same words and phrases. And we have a way to shut that down, and that is res judicata. And it's appropriate in this case. These are exactly the same arguments. These issues could have been raised in the prior litigation, and they were not raised. And therefore, it's perfectly appropriate, in addition to all the plain language and other issues that we've raised, for the Court to simply say, based on res judicata, this issue has been decided, and that is over. And we would certainly encourage the Court to look at that very closely. And if the Court has no other questions.
It hadn't been enforced at that point in time, had it?
Yes, Your Honor. It had, I believe, if I'm remembering correctly, they filed suit essentially the day the statute went into effect. And so it was already on the books, but the day it went into effect was when there was a motion for a temporary injunction. This will all be laid out with record citations in the briefs. But before, I believe it's the case that before we really got out of the trial court, they certainly could have amended their pleadings to include an as-applied challenge if they had wanted to.
Let me ask about that, because for purposes of res judicata, it requires a final judgment. So can the fund go back and amend its pleadings after there's already been a final judgment?
No. No, because this is the entire point of having the res judicata system. If you have a complaint, especially about a statute, that a massive pension reform statute that the fund is alleging is unconstitutional and wants entirely stricken from the books, at least as to them, if they want to make that kind of claim, then in their complaint they need to raise all the possible claims. This serial idea that they're going to hold one back and save
Even
it
if
for
there hasn't
later.
been enforcement?
I'm sorry.
Even if there hasn't been enforcement yet of the statute? I think the trial court's judgment was maybe the day before the effectiveness of the statute.
But that would not have prevented them from either moving in the trial court for a reconsideration or a motion for a new trial or any of those kind of standard post-judgment motions that they could have made to make sure that their entire package of claims, whatever they were going to be, was properly presented through the court system once, which is what everybody's entitled to.
So even if there's been a final judgment, they should do it in some format where the court still has plenary jurisdiction? That's where you're saying that should have been raised?
I think the language in the res judicata test is could have been raised. And I think the question the court would have to ask is, could these issues have been raised in the prior litigation? And the answer to that question is yes.
Okay, let me conclude the discussion to be fair to the other side. Thank you very much for your arguments and cases submitted.
All rise.
Well, no, I understand that. Because it seemed like, I told you that before, it seemed like there was some tension. Don't you agree that they have to be passed the report? Okay. Good.
All rise.
Please be seated. We have one remaining case on this afternoon's docket. Governor Greg Abbott, in his official capacity as the Governor of Texas, in the County of Fort Bend, number 0121000453 CV. May we have appearances of counsel, please?
Good afternoon, Your Honor. Cody Call on behalf of the Governor, my colleague Bill Davis from the Attorney General's Office.
Welcome.
And David Campbell, District Attorney, Portland.
Welcome. Each side will have 20 minutes for argument. Does appellant wish to reserve time for rebuttal?
Yes, Your Honor, 5 minutes.
All right, with that, we are ready to proceed.
Good afternoon, Your Honors. May it please the Court. The temporary injunction in this case should be reversed for 2 reasons. First, because Fort Bend lacks standing to pursue its claims against the governor. And second, because the Disaster Act, by its structure and text, grants the governor the authority to preempt the local order in this case. Beginning with standing, that doctrine requires that the plaintiff's claimed injury be redressable by the relief requested, and Fort Bend simply fails that test in this case. At bottom, the governor has no enforcement role when it comes to his own executive orders. As the Texas Supreme Court, the Fifth Circuit, and other courts have concluded, that responsibility, the responsibility to prosecute for failures to comply with executive orders, is delegated by our Constitution exclusively to the county and district attorneys with jurisdiction. Not even the Attorney General can take prosecutorial action of his own in a case such as this. And it is black letter law that courts do not enjoin, strike, or otherwise take action against laws, even executive orders. Rather, courts enjoin those actors who purport to enforce laws that have been found invalid. So here, the county has simply sued the wrong defendant.
Let me stop you for a second. You had cited, I think, 4 Court of Appeals cases that have been decided on this issue. Are there any issues that remain unaddressed by those 4 Court of Appeals cases that we need to address for the first time, or do those more or less cover the waterfront of your arguments here?
Well, Your Honor, those cases do cover, generally speaking, the breadth of our arguments. However, the Dallas Court of Appeals and the Austin Court of Appeals specifically did not address each of our arguments in turn, and in fact, we believe have omitted to and failed to consider certain arguments that would be dispositive in this case, namely the government's authority to preempt the local order here. And that authority is found within the Disaster Act itself.
Can I ask you about that? What specific provision are you talking about? Is it 418.016?
No, Your Honor, that would pertain to the governor's power to suspend statutes. What I'm referring to are 2 provisions earlier in the Disaster Act, specifically 418.011, which gives the governor the ultimate responsibility to protect the state and its people from the dangers presented by disasters. And then immediately following, the statute that gives him his most effective mechanism, which is .012, that says the governor may issue executive orders with the force and effect of law.
Okay, I have a question about that, because those 2 provisions just merely tell me what is generally understood, that if there's an executive order, obviously it has the effect of law. Equally true is the fact that the authorities, both constitutional and statutory, that give authority to the counties to promulgate laws or orders themselves also have the effect of law. So I don't read section 418.012 or 11 as giving the power of preemption.
Well, Your Honor, the power of preemption generally is a matter of the common law of this state. And to be clear, the county cites no constitutional provision that provides it an express authority to promulgate the order in this case. They rely purely on statute. And in this state, we look to the legislature to expressly grant powers and authorities to counties, as opposed to home rule cities, which have inherent powers that the legislature may limit. And just as the legislature may grant powers to counties, they can also take those away in the same way they can limit home rule cities. Here, by granting the governor the authority to enter an order which carries the force and effect of state law, which is the effect of .012, the legislature has made a permissible delegation of power to the governor to act on the behalf of the legislature and the state to limit the authority of the county. And as a later enacted and more specific state law, GA 38 validly preempts the local order here because it restricts the authority granted in other statutes that the county relies on, whether it be the Disaster Act, the Health and Safety Code, or the Local Government Code.
But doesn't preemption require some type of action? I mean, can the governor choose not to act, such as he did here, to strip local governments of their express authority to act to protect their citizens?
GA 38, Your Honor, is an action taken by the governor to promulgate that executive order, and it narrows the scope of the county's power under the statutes that they rely on.
The executive order then would have the effect of law. but only to the extent that the governor exercises its authority as provided for under the Texas Disaster Act. And so in relation to that question, the executive order suspended certain laws. So can you address why the governor's executive order was compliant with its, what I see, a very limited ability to suspend laws to prevent the local authorities from issuing their own laws that address, in this case, the face mask mandate?
Yes, Your Honor. So the first thing I would say to that is that it's very important that we not conflate the preemption and suspension issues here. And the fact of the matter is that neither of those is superfluous, because the preemption power applies to the local order, whereas the suspension power applies to state statutes. And that would include the statutes upon which the county relies for the authority to promulgate its order, but those powers are separate. So the governor has this preemption power, which is separate, and in fact can be the end of the court's analysis, and the court need not reach the suspension argument. However, the governor does retain the power to suspend the statutes that the county relies upon, because they are regulatory statutes that prescribe the procedures for the conduct of state business. Regulatory, to begin, is not defined in the statute, but it simply means to control or govern by rule or law, and that is certainly something that all of these statutes upon which the county relies does.
Why are the acts of a county government state business?
Well, Your Honors, there's two answers to that I would give. The first is that where the Disaster Act means state level business, i.e. stemming from Austin or state agencies, it uses the term state agency. And here, in this particular clause of this particular statute, it uses the term state business. And as far back as the Childers County versus State case, the Supreme Court has recognized that the state often uses counties as its agents for the conduct of state business. And the Disaster Act reflects that as well. The Disaster Act establishes that emergency management directors, namely the county judge in this case, act as the governor's agent for the administration and supervision of duties under the Disaster Act. And so where the county promulgates an order in response to a declared disaster, it must do so with the governor, the principal's wishes in mind. The county offers no alternative reading of the word agent except to read it out of the statute. But agent, an undefined term, must be given its ordinary meaning, which here establishes an agent-principal relationship.
What's the limit on state business? That seems pretty expansive.
Well, in this case, Your Honor, it must pertain to the statewide disaster that's been declared and the county's response to it. After all, the governor has the ultimate responsibility under Section 418.011 to meet the dangers presented by that disaster. But of course, there are activities that the county might undertake that would fall outside the ambit of state business, but they're not necessarily presented by this case.
A follow-up question just on the suspension provision, section 418.016. I know you say that regulatory is not defined, but it talks about regulatory statute prescribing specific procedures. And so does this not apply truly to procedural laws or rules or regulations, as the contextual terms of the section say, that would require strict compliance with the provisions, orders, or rules, and strict compliance with them prevent, hinder, or delay necessary action in coping with a disaster? And so can you explain to me, when the executive order was passed, it was not in effect suspending existing laws that would require conflicting compliance, but it was prescribing conduct that might be future. In other words, the rules or laws or orders rather that the counties would pass to address this specific issue. And so can you explain why, the suspension of, quote, all relevant laws, as the executive order provides, falls within the confines of this very limited suspension authority?
Yes, Your Honor. So first, again, the executive order does not purport to, nor could it suspend Fort Bend's local order. It suspends the statutes that the county relies on for its authority to promulgate that order.
And perhaps that's my point. Why does the Texas Disaster Act allow the governor or give the governor the authority to do that? Based on this provision that we're relying on?
For example, Your Honor, the county relies primarily on 418.108G for its authority to promulgate this order, which grants the county the authority to regulate or control the movement of persons and occupancy of premises within the disaster area.
And that's not based on agency, is it?
No, Your Honor.
That's an independent right.
Yes, the county has that authority under 108G. Now, the governor has the parallel authority under 018, and I can touch on that in a moment. But to answer Justice Rivas-Malloy's question, that statute regulates and prescribes the procedure for who may, within the disaster area, control the movement of persons and occupancy of premises. As to the second part of that sentence, pertaining to whether or not that statute would hinder the state's response to the disaster, that calls for the governor himself to make a factual determination about whether or not strict compliance with that statute, in other words, strictly permitting the county to exercise that power, would hinder his overarching statewide response to the disaster, which is his responsibility, again, under section .011. And now to touch on these parallel powers in response to Justice Hightower, this is exactly the tiebreaker question in this case, right? The county has this power under .108G to control movement of persons, occupancy of premises. The governor retains the identical power under .018C. Now, section .018, immediately after it grants this power to county judges and mayors, dictates that when there's a conflicting order between a county judge and a home rule mayor, that the order of the county judge prevails. And this is in contravention of the ordinary hierarchy of authorities, because in Texas, again, we apply home rule to most incorporated cities and quote-unquote Dillon's rule, restricted authority for counties. And so under a long line of cases from the Supreme Court that are cited in our briefs, the orders of a home rule municipality generally control over the orders of a county. So the legislature knew that it had to alter that common law principle when it passed the Disaster Act. On the other hand, the orders of the state, the laws of this state, always prevail over countervailing or contrary local orders or ordinances. That is also the common law. So the legislature knew that it need not insert such an express tiebreaker for the governor's orders to have preemptive effect. But they did anyway by explicitly saying in the Disaster Act that those executive orders carry the force and effect of state law.
But couldn't they have said that like they did between the mayors and the county judge and expressly say that?
They could, Your Honor, but again, that's simply a matter of the common law in this state, that the law of the state prevails over contrary local laws. I would like to return to the standing argument that we have, just in closing again. To reiterate, the governor has no enforcement power when it comes to enforcing this executive order against the county. That is solely the responsibility under our Constitution, as recognized by the Supreme Court, that of the district attorney for Fort Bend County. And so the county simply sued the wrong defendant here. Any injunction that the trial court could enter would be wholly ineffective to relieve the county's claimed injury, as courts don't typically enjoin actors or parties not before them. So an injunction on enforcement against the governor would leave the DA free to prosecute county officials for violations of the executive order. So the only effective relief that any court could grant against the governor would be an injunction requiring that he rescind GA 38, but under Texas Government Code 22.002, that injunction could only issue from the Supreme Court because it would require the governor to perform a discretionary act.
Well, but doesn't that provision only apply to the extent that the Supreme Court would be ordering the governor to take affirmative action and not to enjoin the governor from taking certain action?
Yes, Your Honor, but that's my point precisely, is that any injunction that would order the governor to rescind GA 38 or to issue a superseding order would require him to take a discretionary action and would not, on the other hand, forbid him from acting. On the other hand, an injunction on enforcement forbids the actor from acting to enforce the law that's found to be invalid, and that would be ineffective to relieve the injury here, the claimed injury here, because the governor has no enforcement role, and any injunction against him would leave the DA free to prosecute. Unless there are any further questions, I'll reserve.
I have a quick question.
Yes,
if we have any interpretive questions about the Texas Disaster Act that was passed in 1975, are we supposed to look at a dictionary produced in 1975, or do we go with the provisions year by year as they were added? I mean, what is our way of analyzing any questions that we have about definitions.
The court would apply the ordinary and common meaning of any term that's undefined, and that could mean dictionaries contemporary to the time of passage. It could also mean looking to cases such as Abbott versus Anti-Defamation League from 2020, the Supreme Court case, which expounded on the governor's authorities under section .011 and 012. And it could mean looking to dictionaries contemporary to this case now. I see that I'm out of time. Thank you.
May it please the court. I made a few notes to hit on some specific questions that the court has asked, but first, with your indulgence, I want to take a step back and talk about kind of the big picture, what we're looking at here. Because the Texas Disaster Act, I think when read with fidelity to the text, the context, and keeping in mind the consequences of the interpretation, really undermines the interpretation that the governor has offered in this case. In looking at the consequences, you can see that there is no limiting principle on the governor's interpretation of his authority under the statute, and that's extremely problematic because the Texas Disaster Act, essentially, if you look at the purposes of the act, at the very beginning, attempts to give additional powers to the governor, but not the governor alone, also to local authorities and to the judiciary. And the judiciary really isn't primarily discussed in the Disaster Act. Instead, the legislature put that authority in section 22.0035 of the Texas Government Code. So if you take the governor's argument that this force and effective law gives him carte blanche authority to enact any order he wants, what the governor is saying is that at any time during this pandemic, the governor could have ordered the Texas Supreme Court or this court that Zoom oral arguments could not be conducted. The governor could have come to this court and said that when masks were required, that you were no longer able to do that. That is not what the Texas Disaster Act set up. Instead, for better or worse, the Texas Disaster Act set up a system where multiple different governmental authorities were given additional powers with the idea that the governmental authorities would work together. I think Justice Rodriguez actually said it well in her dissent in the El Paso case when she said that the idea of the Texas Disaster Act was that the governor would help local authorities by clearing red tape. And it is troubling in this case that instead the opposite has happened. Especially when, as you saw in this case, there was testimony at the temporary injunction hearing that in Fort Bend County, at the time of the injunction hearing, one of the nurses testified that not only were the emergency room beds filled up, they were filled up and to overflowing to where they had patients waiting for emergency room beds. So with that big picture, I think, problem in the governor's argument, let me address a few specifics. Justice Landau, you had asked about the other court cases. I do think that those cases, especially along with Justice Rodriguez's really thorough, well-reasoned dissent in the El Paso case, respond to all the arguments that the governor has made in this case. Let me touch on a few of those arguments just to give the court a few additional thoughts that I think provide some additional flesh on the bones for arguments that the courts have offered in those cases. On preemption, I don't think I saw argued in their brief any argument of a common law preemption right. I think I heard it twice today. I'm not aware of any common law preemption right in Texas. Preemption is created by the Constitution. The federal government doesn't preempt state law because we've just decided to let them. It's because the United States Constitution says that the supremacy, establishes the supremacy of those laws. Similarly, in the Texas Constitution, the reason that the legislature does have preemption power is because when the Constitution granted authority to counties, it is specifically pursuant to the laws of the state. Now, on preemption, there have been a lot of assumptions about what the language force and effective law means. And I want to add two additional thoughts that I haven't seen discussed in the cases for the courts. I think it's helpful. if you go to Westlaw and look for that phrase, force and effective law, you will not find preemption clauses pop up. Instead, what you will see is a number of statutes giving authority to administrative agencies to enact regulations. That's what 012 and the Disaster Act gives the governor. And in fact, you don't just have to look at that language. You can actually also look at the text of the Disaster Act itself, because in 012, it gives the governor the authority to issue executive orders, proclamations, and regulations. And
Well, can I ask you a question then? Then what are our guiding principles in evaluating preemption, especially in the situation, well, not this situation, but in a situation where there is a statewide disaster and there are conflicting orders from the governor and local authorities? How are courts to resolve that issue? What are the specific preemption principles that we are to look at to make sure that there is, as the state puts it, no chaos, and that there's uniformity in the ability to work collectively to address a statewide disaster?
So this is actually a question that I've struggled with a lot and given a lot of thought to in this case. So let me see if I can answer it 2 or 3 different ways. First, I want to acknowledge that I don't think there's a clear answer in the statute. Or at least there is not maybe an answer that we would want. The statute, unlike the provision that discusses what happens when there's a conflict between a mayor and a county judge, does not resolve what happens when there is a conflict between a county judge and the governor. Now, what the Fourth Court did with that is to say, when there is a conflict, there is nothing in the statute and in the Constitution that gives the governor preemptive authority, and so we have to live with that conflict. Now, Justice Rodriguez, in her dissent in El Paso case, recognized that as well, and her view of it was, that's not ideal, but in my robes, I can't make a policy decision. That is what the words of the statute say, and so unfortunately, that is the situation that we are in. I would say that in practice, that hasn't typically been a problem, because I think the idea behind the Texas Disaster Act in the past was that there would be collaboration. Now, just as a practical matter, if we step away from the law for a second, I don't think that's unworkable. It does lead to some conflict when someone decides to dictate what they think they're going to do. But let me give you 2 practical examples of why I think that is a workable standard. And if the legislature disagrees, they can change it. They can amend the Disaster Act. One, I reflected just personally on my marriage. I have 4 kids and a wife. Now, we both have control over the movement and occupancy of our children. We don't always agree on everything. So when we disagree, I don't declare that my order preempts hers. We work together and try to work something out. Is that unworkable in government? I actually don't think so. Early in the pandemic, in March of 2020, the governor scaled back some of his early reactions to the disaster and was getting criticism for that, and said, I am choosing not to act because we have a state with 254 counties and some with 4.5 million people like Harris County and some with 100 people out in West Texas. And so I don't feel like I need to take that restrictive step of issuing a stay-at-home order or whatever. However, if local authorities feel differently in their counties, they can take more restrictive measures, and I would applaud them for doing so. And I actually think that is the way the Disaster Act is supposed to work, in collaboration with the governor taking the measures he feels are appropriate on a statewide level, and on a local level, if more restrictive measures are needed, then they can occur. One additional point.
Who gets to decide?
Right.
Well,
Someone has to decide.
Right. So one additional point on that as well, because to what Justice Hightower said earlier about doesn't preemption require action, I don't think that's true as a general principle. I think the legislature can preempt by just stating that something's not allowed. The reason I think that principle does apply in this case is because of the statute the governor relies on for his authority. Because in the Disaster Act, what the governor relies on is the ability to control movement and occupancy. Control. So I think it would be an extremely difficult case for the court if you had a situation where Fort Bend County adopted a mask requirement and the governor said no one can wear masks. What we have in GA 38 is something very different. It is not the governor deciding how to control people. It is the governor deciding, I'm scaling back my authority, I don't think we need to do anything, and I'm going to tell you that you can't do it either. I think that is where there's maybe a subtle but important distinction on what the governor is trying to do in this case. So,
what about the inverse of that? The governor says wear masks and the county says no more masks.
So in that situation, I'm not sure how the court would resolve that, frankly, if we flipped it and the governor required it and the county didn't.
Because that's an action by the governor.
Right.
And contradictory local action.
So I think that in that hypothetical situation, I think, well, it would depend. And here's why I say it would depend. In our brief, we had mentioned, of course, that some courts that have struggled with this and trying to figure out what to do when there's no constitutional preemption provision that applies and there's conflict, that there is that local, the doctrine that the local authority prevails. So that might be one way that the court would resolve that conflict between the governor and local authority, is to say where we have nothing else to guide us, no constitution, no statute, the local authority prevails based on the case that we cited from, I think, Webb County. The other, if the court did not adopt that doctrine in a case, I think the other way that the court could resolve a situation like that is to say the local authority is telling you don't wear a mask. The governor is saying that you do, and in that case the strictest would apply. I don't think that that's, to me at least, necessarily a satisfying policy decision, but I do think that that is one reasonable interpretation of the statute. What I don't think can be read into the statute is some kind of de facto rule that the governor is going to preempt a local authority. I think that's simply the reason the statute language is not
Doesn't
there.
the governor somewhat have other concerns that fall into that, such as the economic movement forward, that we're not just talking about mitigation through a mask, but we're talking about the overall concept of people getting better, returning back to economy and things of that nature?
Sure.
Does that play into this?
So it plays into the governor's decision on what he's going to do, and that was what was at play in the defamation league case, right? That certainly you can't argue that because the governor could take a stricter measure that would save lives that he has to, because the governor or local authorities or the courts, when they're making the decisions about how to respond to a disaster, are going to take that all into account. But the difference in the defamation league case is it was whether the governor has the discretion when he's exercising his own authority to decide to ratchet it down or ratchet it up. It's a very different thing for the governor to step out of his authority and now tell local authorities or the courts, I've decided that we're done with the pandemic. I've decided that because of those concerns, you cannot exercise your statutory authority. So while I think it's appropriate for the governor to take account of those in exercising his authority, it is not appropriate for him to impose that decision on other co-equal branches of government.
Let me follow up on that. Would an example of that be the suspension of state regulations of the sale of alcoholic beverages to permit to-go sales? Would that be something that kind of is taking kind of a wider look at the situation in the pandemic and not just the public health crisis response that would be lawful under your reading of the statute because it doesn't trump another unit of government?
Yeah, I think so. And you know, with that example, you know, if you look at the suspension clause, under principles of constitutional avoidance, I think the court has to start with whether or not we can read that statute in 016A in a way without reaching the underlying constitutional question about the suspension clause. And I think when you do read the language that Justice Rivas-Molloy mentioned earlier, the governor could decide potentially that doing something like that is, you know, suspending that law is necessary for, is necessary because the statute would prevent, hinder, or delay necessary action. In that situation, it might be because you're going to have more person-to-person contact when people are buying alcohol, right? And I think in our brief we talked about election statutes that we think fall comfortably within 016. And I'm sure there are others. I mean, I didn't look up the statutes, but I would also presume that 016 would comfortably cover purchasing type statutes where you have to, have a certain number of time for bids, get a number of bids. Those might be other statutes that are regulatory statutes prescribing the procedures for the conduct of state business. And I know we mentioned it in our brief, but I'll just highlight it again that I do think when you read that provision in context, you do need to look at the other statute before it, which requires the governor to keep a list. The idea is the governor is not simply going to declare an order and then say, I suspend any statute that anyone cites to say that my order is unlawful. That is not what the legislature contemplated in the Disaster Act. I think while we're talking about that suspension clause, the one other thing that I would say is my friend on the other side, Mr. Cole, said you really need to not conflate the preemption and suspension provisions. I really disagree with that. I really think you have to read them together. Other courts have done so as well, and the reason they've done that is because when you look at the governor's interpretation of those statutes, if you accept their interpretation of 012, you're left asking, why is the rest of the act there? Why would you have a limited suspension power if the governor can just declare what the law is? And similarly, with the suspension power, why would you have this limited suspension power, vice versa? So I do think it's important to read them together in context to understand what the legislature was trying to do in the Disaster Act.
Would any local authority, like what the county did here, that the governor suspends, but it have to prevent or hinder or delay the governor in coping? I mean, isn't that the limitation on powers? The governor could have to do anything he wanted to just because there's a disaster. What he suspends wouldn't, whatever's in place by the county authority, somewhat have to hinder, delay the governor in coping with the disaster. Is that a requirement?
Well, right, and not just the governor, but I would say in coping with the disaster generally, because of course the disaster is being coped with by all levels of government, all the way up and down the ladder. And so, what this provision does is, I think in an attempt not to run afoul of Article 1, Section 28 of the suspension clause, tries to narrow this authority as much as possible. Because we know from the delegation cases that the legislature can delegate authority to regulate as long as it is, clear, limited, doesn't conflict with other statutes. And with the suspension clause, there haven't been that many cases of, they're older ones. So it's been a while since anyone's tried to do it. But I think that's what this statute tries to do, is really narrow the suspension in a very, very limited way so that it only applies to regulatory statutes prescribing the procedures for conduct of state business if it is also true that it would in any way prevent, hinder, or delay necessary action. And I think it's important under the facts of this case to remember the governor's order itself recognizes that wearing masks is the least restrictive way to respond to COVID. I mean, I can't tell you how happy I am to be able to be here in person, not wearing a mask. I don't love it. And I'm thankful that we are where we are, and that we have the vaccines, and that we've gone through the other side of Delta. Of course, Fort Bend County's concerns of a lot of local governments out there, and the reason that these cases are still here is because we've been down this road before, right? I mean, we came out of the initial surge. In that year, I remember the feeling that we were finally done, and then Delta hit.
Mr. Campbell, before you run out of time, can you address the standing arguments the state made?
Sure, and I'm glad you brought that up, because I do want to step away from enforcement for a second, because I think every court that has addressed this has pointed out that clearly the governor has said he was going to enforce it. And in our brief, we also mentioned that under the Disaster Act, the governor has the authority to enforce it because he is the commander-in-chief of state agencies, which includes the Office of the Attorney General. I don't think that enforcement is actually necessary for standing in this case. I think that the court could write the opinion that goes through injury, traceability, redressability, the same way the fourth court, third court wrote their opinions. in fifth court. But I actually think that in an ultra vires claim, standing is established when you sue the official who's done the ultra vires act. Those enforceability requirements, if you really go back and read the cases, have to do with federal cases involving ex parte Young, where in federal court you can't sue a state, you can't sue a law, so you have to sue the official responsible for enforcing the law. In state law, those state cases, I think, have focused more on the problem of advisory opinions, and saying just because you're concerned that a law might be enforced doesn't mean that you can sue the DA unless he's actually going to enforce it against you. That same
So
enforceability.
your point is that you need to actually name as your defendant the entity who abused, for better for word, the authority, or is not, pursuing, either acting outside of its authority for your ultra vires claim.
Correct. Yes, Your Honor. And I see my time is up, and so unless there are further questions.
Can the Attorney General enforce if the local DA does not choose to enforce?
That's an open question that's working its way through the courts. I actually think, especially with the recent Court of Criminal Appeals opinion on the election statute, the answer may be no. I can tell you that those lawsuits have been filed, and under just a basic definition of enforcement, enforcement is compelling adherence to, I guess you can look up a dictionary and get a better definition, but certainly the Attorney General has filed the lawsuits and has compelled people to follow the executive order. And in the record, there are those threats to do so in this case.
Oh, I have one logistical question. Is Corcoran County still under an emergency designation?
So I checked on that yesterday. The masking requirements are not the same that they were when the temporary injunction hearing was in place. The order is still in effect because the governor's order is still in effect. And so the way that they have done their local emergency order is as long as the governor keeps re-upping every month his emergency order, they have been re-upping theirs.
Thank you.
You're welcome. Thank you.
Your Honors, I would like to touch first again on standing. And again here, my colleague made the statement that standing is established in an ultra-virus suit when you sue the actor who has committed the allegedly ultra-virus act, but that simply cannot be the end of the analysis. The Supreme Court of Texas has adopted the federal Article 3 test for standing, which requires injury, traceability, and redressability. And here, the county simply fails the redressability prong. The governor, even as commander-in-chief of state agencies, cannot direct the Attorney General to take action which the Attorney General could not take uninvited, which would be prosecution in a case such as this. And an ultra-virus lawsuit is simply not an enforcement action. For example, here, the county does not sue the governor seeking to enforce its local order against the governor.
So who would be the appropriate defendant?
The district attorney for Fort Bend County.
The district attorney did not pass the executive order, so how do you establish an ultra-virus claim against the state attorney or the district attorney? Because they didn't exceed, as I read it, they have to establish that the officer who's being sued acted without legal authority. And so in this case, the district attorney would not be that official. So would you not be arguing then as the state that they sued the wrong entity and that their ultra-virus claim fails for that reason?
Not at all, Your Honor. The county would come and establish that there's a credible threat of prosecution by the district attorney. That would be injury, and for that matter, traceability. And for the ultra-virus claim, they would say that it would be an ultra-virus act to prosecute based on GA-38 because GA-38 is itself invalid. And that would be the basis of the injunction granted against the district attorney. I'd also like to touch on some of the merits issues again as well. Another thing that my colleague mentioned was that we've put forth no limiting principle, but of course the overarching limiting principle of any government action is both the federal and state constitutions. The overall structure of the Disaster Act and various provisions of it also establish limits on individual authorities of the governor. And then in terms of whether the governor could order the courts to behave in certain ways, that would of course encroach or rather approach separation of powers issues. And none of these limiting principles are at issue in this case because they're simply unpleaded. The county has not pleaded any ultra-virus theories that the governor has exceeded, has violated constitutional rights, has violated separation of powers principles, anything like that. Those theories remain unpleaded. In terms of preemption, this is not a case about either field preemption or express preemption as we think about those concepts regulating the relationship between the United States and the various states. Rather, this is a simple matter of long-standing law in Texas that a local law that is repugnant to state law is simply void. It's invalid. It cannot be enforced over and against the contrary state law. That is inherent in the relationship between the state and the county because, again, as the Supreme Court has long held, though counties are creatures of the Constitution, they have no inherent powers for sovereignty of their own. They derive those powers and sovereignties from express provisions in the Constitution or express grants by the legislature. And what the legislature has taken away, has granted, it can take away. And just as the valid rules and regulations promulgated by agencies carry the force and effect of legislation, and that's Lewis versus Jacksonville Building and Loan, 540 Southwest 2nd at 307. The governor's orders, which expressly the legislature has granted, carry the force and effect of law, also carry the force and effect of state law, and are valid to preempt contrary or repugnant local orders. I'd also like to touch on this idea that there need not be a tiebreaker. There must be some tiebreaker in this case. The relationship between the county and the state is not a co-equal marriage, and the rule of law must dictate that some authority has the final say.
And that would be section 418, 012, and 011 in your view?
Yes, Your Honor, primarily yes, for our preemption argument, that's exactly correct. The other key thing on this point is that the San Antonio Court of Appeals rendered its decision agreeing with the governor's position on this preemption issue before the beginning of the 2020 regular session of the legislature. The legislature is presumed to have been aware of that decision and chose not to act to modify that interpretation of the Disaster Act, despite multiple bills having been presented during that regular session that would have or could have modified the Disaster Act. And so this idea that the legislature can change the relationship between the governor and local officials in the Disaster Act, of course it can. It's simply chosen not to, and it's chosen to impliedly adopt the San Antonio Court of Appeals.
Were the proposed amendments, did they address the suspension or preemption sections that you've addressed in your argument?
I'm not sure the answer to that, Your Honor. Thank you.
Thank you. Thank you for your arguments today, counsel. The case is submitted.
All right.
Thank you. I was involved in reviewing some of the briefing and then moving the attorney that made our argument in Dallas, but I just picked this back up. Yeah, that's pretty fun. Moving really involved everyone. Yeah. Who was this? Billy Cole.